God is dawn. Like and subscribe. Comment some night. Love in this light. Here's God is dawn. God is dawn. God is dawn.
Peace world. Welcome, 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 or welcome back. I'm Goddess Dawn, the queen of info. Shout out to Hot Rod for that tag. He is a content creator here on YouTube. Check him out. He's a good guy and definitely one of the few you'll find here on YouTube. Shout out to you, Hot Rod. Thank you. But yeah, I'm back with another R. Kelly update, the New York case, which includes a RICO charge and Mann Act allegations. As we move closer to his New York federal trial, we're seeing more activity in the case by the way of motions and whatnot. If you've been paying attention to the case, aka listen to my channel, yeah. Now, let's get into it. Like I said, the closer the trial gets, it's currently scheduled for April this year, just a couple of months out. The more activity we're seeing with the filing of motions and requests for status hearings to clear up miscommunications between the defense and the prosecution, it's already shaping up to be quite the intense showdown. So far, the prosecution is on top, with R. Kelly having been denied bond 6 or 7 times since his jailing July 11, 2019. Prosecution seems to have the upper hand with getting the judge to order in their favor for, I would say, every time they filed a motion, every argument, every filing. Yeah, so far they're winning. The latest is the defense filing a motion to compel an effort to speed up the delivery of certain discovery materials from the prosecution. The government responded by saying they emailed the defense the prior week, letting them know when to expect these materials, and also expressed concern for discretion that will be and whether or not the integrity of the law will be upheld with regard to the discovery. The threat of witness tampering and obstruction loom over this whole case, and the prosecution doesn't want to risk the information getting into the wrong hands. A lot of man hours have been put into this operation, and no one wants to see this thing fall apart because evidence has been compromised. This actually brings me to another point, and that is there are certain YouTubers who report on R. Kelly that have gone too far when it comes to inserting themselves in these cases. There's a broad line between reporting the news and being the news. This R. Kelly situation is not a game. I've never been quiet about even how I feel about Azriel doing and saying anything publicly about R. Kelly and, her experiences. As much as I want to know, I think it's more important that we make sure the integrity of all of the information is kept intact. And I especially feel it's out of pocket for anyone she's connected to also to say anything outside of what's being reported in the news or filed on Pacer. There's a lot of lies out here, a lot of cap, a lot of unnecessary competition, a lot of one-sided competition, a lot of collusion, and a lot of EVIL, and that's evil. The devil is real in these YouTube streets. And it's sad to see that there are so many who are aligning themselves with the devil, so many who support the channels who are doing his bidding. But it is what it is, right? The world we live in, it's a physical manifestation of the spiritual realm where the war between good and evil continues to wage, causing negativity and toxicity. And with that, a very clear divide between people individually and collectively here in this physical 3D realm, the matrix. And yet still beneath it all, Mother Earth sits here on her throne in the universe. She's the empress whose kingdom has betrayed her on so many fronts. Pollution, pillaging, plenty to go around, but only going to certain persons. The ones willing to go along with the get along for clout and for a bag at the expense of their soul. Make it make sense. But back to the case. In preparation to hand over the 3,500 materials or the discovery, the ones with regard to law enforcement testimony and witness info, the prosecution filed an order to protect the discovery from whoever's eyes don't belong. That goes for R. Kelly's jail friends, including COs who let him use their cell phones and whatnot, to whoever. Let me read a little bit of what the government has filed. As you can see, the government's filing is up on the screen. I'm just going to read a little bit of it. Well, I'll read some of it because they point out some details of why they feel the protective order is necessary. Dear Judge Donnelly, the government respectfully submits this letter to request an order requiring the defendant to preserve, to not disseminate, and at the conclusion of the trial in the above referenced matter, to return all material produced pursuant to 18 U.S.C. 3500. As set forth below, the defendant has no right to retain such material, and such an order is appropriate in this case. A proposed order is enclosed. And then there's some discussion here with the Jinx Act, which I'm not going to read. And then they go on to describe the reasons. The danger posed to witnesses as a result of the unwarranted disclosure of Jinx Act materials is significant, as set forth extensively in the government's motion for an anonymous and partially sequestered jury, which motion the court granted, and prior memoranda. The defendant has a history of obstructive conduct, including the following, and potential witnesses have already been subjected to significant harassment. So there you have it. The government is already laying out the fact that there is a history already of obstruction or obstructive conduct, including and following potential witnesses having already been subjected to significant harassment. And they're not going to put it in here if they don't have the evidence to back that up. So they go on with their examples. It says, in connection with his trial in state court in 2008, the defendant persuaded multiple individuals to testify falsely before a Cook County grand jury. Indeed, the indictment the defendant faces in the Northern District of Illinois charges him with conspiring to intimidate victims and conceal evidence in an effort to obstruct law enforcement, including with respect to an investigation in the 2000s that resulted in the defendant's 2008 state court trial on child pornography charges, of which he was acquitted. Specifically, the NDIL, the Northern District of Illinois, indictment charges that in 2001, the defendant and another individual began paying an acquaintance hundreds of thousands of dollars to collect videos of child pornography for the purpose of concealing and covering up their existence. When the acquaintance later planned to hold a news conference to publicly announce that he had recovered the videos, the defendant and others paid him approximately $170,000 in exchange for agreeing to cancel the event. The defendant and another individual also agreed to pay two persons for their efforts to return the videos, but only after they took polygraph examinations to confirm that they had returned all copies in their possession. So that's the first example, the 2008 trial and the behavioral patterns surrounding that with regard to conspiring to intimidate victims, conceal evidence in order to obstruct law enforcement, including with respect to an investigation. So there's a history. The next example says, following a civil lawsuit filed on behalf of Jane Doe number 6 against the defendant, a lawyer for Jane Doe number 6 received a typewritten letter in 2018. Among the images were photographs of Jane Doe number 6 that had been apparently cropped to not disclose certain body parts. Beneath those photographs was text, including, "I assure you this would not be considered a Sunday go-to-meeting dress." The next two pictures have been cropped for the sake of not exposing her extremities to the world yet. Based on the content of the letter, photographs and text messages between the defendant and another individual, it is reasonable to conclude that the letter was sent at the defendant's direction and for his benefit, advising Jane Doe number 6 of his intent to maintain compromising photographs of her in an attempt to convince Jane Doe number 6 to abandon her lawsuit. On August 11, 2020, a complaint was unsealed charging Don Russell with a pattern of harassing Jane Doe number 6, which began prior to the government's investigation of the defendant, but continued through January 2020 in an attempt to intimidate Jane Doe number 6 and persuade her to abandon a civil lawsuit against the defendant. Another example says the defendant has told multiple individuals, including one as recently as 2018, that they needed to select a side, his side or the other side, and implicitly threatened that selecting the other side could result in physical harm to that person or that person's family. The next example, also on August 11, 2020, 2 complaints were unsealed charging Richard Arline Jr. and Michael Williams in connection with separate schemes to interfere with witnesses the government intends to call to testify at the defendant's trial. Arline Jr. was charged with attempting to bribe a government witness in exchange for her agreement to not testify against the defendant. Williams was charged with setting a car on fire in an attempt to intimidate a government witness. In addition, in a separate complaint, which was unsealed on or about August 14, 2020, Russell was also charged in the Southern District of New York with placing a threatening telephone call to a theater in Manhattan to prevent the December 4, 2018 screening of Surviving R. Kelly, the docuseries exploring allegations of the defendant's sexual abuse of minor girls and adult women. Specifically, in the threatening call, the caller claimed in substance that there was an individual in the theater with a gun and that he planned to shoot up the theater if the screening went forward. And it says, finally, several potential government witnesses have been the subject of repeated threats of physical harm, including death threats via social media posts and messages by individuals who are fans of the defendant and have no other ties to him. So this final point, several potential government witnesses have been the subject of repeated threats of physical harm, including death threats via social media posts and messages by individuals who are fans of the defendant and have no other ties to him. They are not stating anything here that they don't have evidence of. I'm just going to continue to make that point. In light of the defendant's history of obstructive conduct and the involvement of others, including strangers, in schemes to harass, intimidate, and physically harm potential government witnesses, there is a significant risk that civilian and victim witnesses who may testify against the defendant may be subject to harassment or far worse. Dissemination of Jinx Act material increases the risk to such witnesses, even if their assistance to law enforcement has previously been disclosed. It goes on to more of the context of the Jinx Act material relating to cooperating witnesses with different examples of different cases. I'm not going to read that. I'm going to go ahead to the conclusion. In this case, given the defendant's own history of obstruction and the extensive harassment of certain potential government witnesses, the government respectfully submits that order restricting the dissemination of 3500 material in this way is warranted. The government also respectfully submits that the defendant should not be permitted to retain printed copies of the protected 3500 material in the jail outside of the presence of counsel. Were the defendant permitted to do so, the government would have no means to ensure that other inmates didn't access and further disseminate the material. Indeed, in light of the extensive coverage and allegations on social media and otherwise, there is a real likelihood that if other inmates learned of the contents of the protected 3500 material, those inmates could have both the motivation and means to further disseminate the contents, and in so doing, cause significant harm to the government's witnesses. For ongoing reasons, the government's motion should be granted and the court should enter the enclosed proposed order. Well, that was more than a mouthful. There's a footnote at the bottom of the final page, which reads, the proposed protective order allows the defendant to retain and access an electronic copy of the protected 3500 material. The government has been advised by counsel for the Bureau of Prisons that, consistent with their practice, the defendant is given access to a discovery computer at the facility to review electronic materials. Now, the defense replied post haste with the filing, basically saying the motion is unrealistic, absurd, and ridiculous. He's no threat. He can't read, so it's going to take him forever to go through the material, which the government describes as voluminous. You can see the response on the screen. Now, I think the word voluminous speaks volumes. They repeat themselves throughout the filing. I'm not going to read their filing, to be honest. I'll read a little bit of it, but with saying that he's not getting a fair shake, how can he properly prepare for trial if he can't review paper documents? It's all about the paper documents for his lawyers. They're good with preserving the documents and not disseminating the documents, and they're good with not returning the materials, and they're good with returning the materials after trial. But they're not okay with a CD containing the bulk of what they're calling the February 5th production, but the 3500 materials and or the discovery with regard to law enforcement and testimony and evidence. But yeah, I'll read a little bit of the response from the defense in opposition to the motion for the protective order with respect to it being on CD versus paper. So yeah, this is coming from Leonard Trial Lawyers out of Chicago, and it's addressed to Ann M. Donnelly, the judge. It says, we respectfully submit this letter on Mr. Kelly's behalf in partial opposition to the government's motion for an order requiring the defendant to preserve, to not disseminate, and at the conclusion of trial in the above referenced matter to return all material produced pursuant to 18 U.S.C. 3500 and for a protective order here as set forth below, after refusing to produce documents, including witness statements that it has possessed for months and even years, the government now attempts to double down by seeking to block Mr. Kelly from having complete and meaningful access to those critical trial preparation materials, which the government is now begrudgingly producing on February 5th. It says, to be clear, Kelly and his counsel have no objection to preserving, not disseminating, and returning all 3500 material. However, by the way of its motion, the government also attempts to overreach and thus simultaneously seeks to bar Mr. Kelly himself from having paper copies of these discovery materials. As set forth below, the government's continued attempt to thwart and micromanage Mr. Kelly and his counsel's ability to prepare for trial should be rejected outright. As an initial matter and by way of background, Mr. Kelly's counsel attempted to resolve these narrow remaining issues by way of a meet and confer telephone conference with counsel for the government this morning, February 2nd. I find it interesting they say resolve these narrow remaining issues. So they're saying that they're small issues, basically. It goes on, notably, during the course of that meet and confer, the government acknowledged that it has no basis for contending that Mr. Kelly has engaged in any recent conduct that could in any way be considered even an attempt at a witness intimidation or tampering. Mind you, he said any recent conduct. See, they slip little words in there so that they're not outright lying, because any recent conduct could mean as of yesterday. How recent are we talking? But I'll go on. Number two, that the information contained within the government's expected February 5th production of 3500 material is already widely known on the internet and throughout social media. Indeed, with regard to that latter point, The government indicated during the parties' meet and confer that if someone were to somehow obtain these witness statements with the names therein redacted, that it would be easy to match up that information with what is already publicly available. That government's admission only underscores the point that there is no legitimate basis to attempt to safeguard, including at the expense of Mr. Kelly's undeniable right to meaningfully participate in his own trial preparation process, information and identities that are already a part of the public domain and widely discussed. Now, of course, they're talking about YouTube. And for the most part, there's Twitter and Facebook too. There's groups and all kinds of communications with regards to this case, including my channel. But what they're talking about is actual witnesses who are being harassed and intimidated. As I said previously, reading the news as opposed to being part of the news, there are two big, huge differences when it comes to being a content creator. So I'll read a little bit more. It says, more importantly, the government's motion wholly ignores the circumstances of Mr. Kelly's confinement, as well as Mr. Kelly's own limitations. As the government well knows, Mr. Kelly has been near lockdown conditions at virtually all times during COVID-19 pandemic. Those conditions continue today. Therefore, the proposal put forth by the government with regard to its February 5th production is entirely unrealistic. Mr. Kelly, like all other detainees, does not have unfettered access to new discovery materials on a computer. At best, Mr. Kelly might be allowed a couple of hours per week to engage in that process, while in competition with several hundred other detainees at the MCC Chicago, who likewise need access to the limited terminals in which to view discovery materials. Therefore, it is even more important that Mr. Kelly be allowed to possess paper copies of these discovery materials to allow for meaningful new review and participation in his own defense. In short, the bulk of his review time will be in his cell. Furthermore, in light of Mr. Kelly's shortcomings in reading, it will clearly take him longer to review these materials. As disclosed today by the government during the above referenced meet and confer, these discovery materials will be voluminous. Voluminous. Speaks volumes, like I said. Moreover, the government's insinuation in its motion that certain of the materials in the February 5th production will somehow allow Mr. Kelly to engage in interference with witnesses and is entirely baseless and speculative, and is directly contrary to the admissions of government counsel during the parties' meet and confer, i.e., that Mr. Kelly has done nothing to suggest, attempt to engage in, much less get away with any form of witness contact, interference, or intimidation on the eve of trial is frankly absurd. As the government itself has acknowledged to defense counsel, the entire internet and social media world is watching, in addition to the government. These alleged concerns of the government make even less sense in light of the fact that it has alleged that Mr. Kelly can receive a disc containing the bulk of its February 5th production. In other words, one way or another, Mr. Kelly will know the identities of the witnesses, either from that disc or from his counsel. Mr. Kelly poses no greater alleged threat if he has paper copies of discovery materials in his cell. And if the government is truly worried that someone will find their way into Mr. Kelly's cell and abscond with these materials, Mr. Kelly would be more than happy to allow the MCC Chicago to take them from him at the end of each night and then return them to him in the morning. The denial of paper copies or any other discovery materials to Mr. Kelly in his cell is entirely inconsistent with the Second Circuit's. Mr. Kelly adequately consult with his counsel under the circumstances presented or under the circumstances that the government is attempting to dictate by way of its motion. He should be allowed to thoroughly review the 3,500 and other discovery materials, including in his cell, and not under the terms and conditions of his accuser. Only then will Mr. Kelly be able to, in turn, meaningfully engage and consult with his counsel regarding these critical materials on the eve of trial. I'll move to the final page. For all those reasons, this court should grant in part the government's motion, but deny it to the extent that it seeks to bar Mr. Kelly from receiving and possessing paper copies of the 3,500 materials or any other discovery materials. Michael Leonard. So, as mentioned in both the government's filing and the defense's response, the 3 individuals who are now pleading guilty have been charged with witness tampering and intimidation, one by the way of blowing up a car in the driveway of one of the Jane Doe's family home. The connection between R. Kelly and or his enterprise has been established with these guilty pleas. The confessions given for the plea deals they obviously took are probably mind-blowing. Well, 2 of the individuals changed their pleas to guilty and are facing sentencing. The third is still up in the air, but if he's smart, he'll plea out also. Yeah, there's a lot of crazy twists and turns with these cases. And thanks to the Me Too movement, Time's Up, Kim Fox, Surviving R. Kelly and the Accusers, Gayle King, Daryl Johnson for the Gayle King interview, classic. And of course, the Savages, the Clarys, Azriel herself, the storage facility, the digital devices, the Beehive, their leaders, the YouTubers, and all of the things in between. R. Kelly is looking at some serious time. Don't believe anyone saying anything different. That includes Tasha K. When someone shows you who they are, believe them. Yes, I'm going to leave it here. Catch me tonight live, or if you miss it, catch the replay. Like, share, comment, and subscribe if you haven't already done so. Also, please join the channel, become a member. As the trial comes closer, a lot of this type of content is going to only be available to my members, well, at least initially. So as a member, you'll get access ahead of the public and exclusive content like lives and tarot readings, meditations. It's doable too, like $1.99 up to $3.99 a month. The link is in the description box. Do it now so you don't miss the first upload. Thank you as always. Much love. Peace.